Good afternoon, everyone. Good afternoon. Good afternoon. We're live here on 107.1 FM. This is The Law and You with yours truly, Shellon Washington, your host. And this afternoon, I have a special guest. I have today with me Claremont Chung, attorney Claremont Chung. And welcome, guys. I encourage you to share the link, share the live as we go live with our program today. Welcome. Good afternoon to everyone, and welcome to you, Claremont Chung. We have Claremont Chung. He's also an attorney licensed in both New Jersey and New York, and I have him here with me this afternoon, and we will be speaking about estate planning. Hi, Claremont, could you greet the audience? Thank you for being here this afternoon.
Well, thank you, Ms. Washington, Shellon, as I know you, for inviting me and believing that I have something to share. I appreciate that invitation, and I want to do the best I can for your audience going forward.
Thank you. As you guys remember last week when we spoke about trust in estates, I did tell you I did have a guest that I was bringing last week, but he had technical difficulties last week. So he's now here with us. And we'll be continuing that discussion on trust in estates. And guys, again, trust in estate is a way to pass down wealth to generations, from one generation to the next. And it's also a way to preserve that wealth if you do it in a very smart way. So today, Clement and I will be discussing some of those ways, as I did last week, of how you can preserve your generational wealth and hand it down in the most secure manner where you're not wasting your assets or giving it away on too much fees, to filing fees and attorney fees and all sorts of fees. Clement, could you tell the audience what is one of the best way you believe they should secure their asset by?
Well, there's no question that trust is a way of avoiding probate. And you want to avoid probate because probate is costly, time-consuming, and it often leads to battles between family and inheritors and heirs that leave bitter tastes in their mouths and could cause more problems than the will was, or the lack of a will would anticipate. So yes, trust is a way of avoiding the cost, quarrels, and time. Now, that doesn't mean that the trust is the beginning and the ending of everything. Some of us have given gifts, decided to give gifts while we were alive to our children. For example, they'll transfer the house into the child's name. But even that you have to be very careful about because of the tax consequences. There are tax consequences in all these different instruments. And the tax consequence of gifting a house to your child is that you gift them the basis, that is the price you paid for the house. So that if you paid $100,000 for the house and you gift it to a child, when that child is ready to sell or otherwise transfer it, and it's $500,000 now in value, you have to pay tax on that difference, $400,000 worth. And it's usually around 17%, somewhere in between 15 and 20%. So you could do the math. That times 4, you're looking at $60-something thousand you got to give the government,
right,
a house that you paid $100,000 for. So it's not just the time and the cost of the will, but you have to look at tax consequences. And though I'm not a tax attorney, and you can't take what I'm saying as legal advice, it is certainly a direction that you need to when you are in that position, to consult on the tax issues, the tax consequences of what you're doing. So yes, and I mean I could go into why trust additionally, but I think Shellon, you know as well as I do.
Yeah, we're going to get into as much as we can this afternoon. Thank you guys so much for joining. Share the live, share the link. Good afternoon. Good afternoon. Thank you for joining us. Those of you who are now joining this program this afternoon, The Law and You. I'm your host, Shellon Washington, and this afternoon I do have Claremont Chung, an attorney, also with me. Now, you did hear me speak last week about some of the tax consequences, and then you heard Clement mention it today. And I know he mentioned about transfer and capital gain. That's one of the things you pay on, capital gain on the property. But there's a way to avoid it. It's based on your residency in the state of New York and the length of time you own the property. So if your children intend to hold on to the property for a while, then you could find a way, the child could find a way around that. But like Clement said, and I said last week, the best way I would advise most people is to create the trust, have a trustee, and have successive trustees, trustees who takes over after one trustee might pass away or retire. You have to name a successor, or the trust must make provision that a new trustee could be appointed if something happens to one of the trustee. Either the beneficiaries could have the power to appoint a trustee, or there must be some sort of provision in that trust. So absolutely, Clement is right on that one. And I do, as I said last week, I did recommend to you that is one of the easiest way to create generational wealth. Now, Clement, let's talk a little bit about the will. Let's talk a little bit about the will, because a lot of people are still making wills. And my advice to most people, most Afro people from the Caribbean, Africa, our people, mostly I recommend for them to skip the will. Skip the will. That's my recommendation. But if you can't afford a trust and you say you want to do a will, could you tell people a little bit about the will and some of the pros and the cons that you see in terms of creating a will versus a trust? I mean, there's good aspects to it and there's bad. So could you discuss some of those aspects to the audience?
Well, I don't see why they would want to do the will vis-a-vis the cost, as you mentioned. I think there's a way that I'm sure reasonable attorneys will be able to walk you through the costs. The initial cost might be higher in the case of a trust, but the later cost of a will would overcome whatever you saved in doing the will upfront because of the time, attorney's fees to the court, and you have no idea how long a probate might you have no control. I've had wills that have been in court now 6 years. Uh, that's a lifetime for an attorney, and you know that wasn't what the person who wrote the will contemplated. So that alone, the time alone, is cost. But you know, the will has served it's can serve some purposes. I mean, it gives the the executor, certainly the person writing the will, the testator, who's the person whose will it is, a kind of peace of mind. You know that they've said what they're gonna say, they're given what they're gonna give, in while they were in their right mind, which is important because you can't give something when you're not in your right mind. That's the reason to challenge the will. But they're in their right mind. They give to the persons that they intended. Uh, you can. There are probably things you can give in a trust that you might not give in a will that you might not want to put in a trust, like personal items, jewelry. You know, the little things. Um, and then you leave it up to the executor, somebody you trust. You designate who that person is, and uh, that to me, there's no real great benefit of doing a will that I can see, except then there are estate taxes that might have to be paid if your estate within the will is greater than I think $1 million is the cutoff now.
Yes,
The
yes.
federal. So I mean, if I guess if you're not over 1 million, then it's okay. If you're within in New York, if you're lower than $30,000 in value, you don't have to do a full probate. You can do a what they call, I think, a quick probate, and it doesn't cost as much. It doesn't take as much time, and you can disperse of smaller items like jewelry like furniture, and so on. But I really don't see any great benefit to doing a will with the information that we have.
I mean, absolutely. And then there's the other problems with the will that a lot of people don't foresee somebody coming and challenging the will, the validity of it. As like you mentioned before, somebody might say the testator wasn't in his rightful mind, or the testatrix wasn't in her rightful mind at the time the will was created. So I think it leaves a loophole that somebody might step in and try to challenge the validity of the will. Or worse yet, what if the will wasn't properly executed? And then that could create another problem. Then you end up litigating. So I think it's always better to consider a trust than before a will. Because if you go with the will, you're looking at attorney fees. Because even though it might not cost that much for the filing fee, some attorneys, if you don't have money, and this is a problem I've mentioned before in this program, a lot of times our community, the people just do not have the money to pay these attorneys. And then if they don't have the money to pay the attorney, then they end up having to pay a percentage of the estate. And then, I mean, that kind of reduces what comes back to you. So that's not the most cost-effective way of passing down your generational wealth. The most effective way is, like I said, like you said too, the trust. Even though you're going to spend a little bit upfront, that's fine. You spend the money upfront and you save it later, because if you wait later, you might spend a whole lot more than it would have cost you to simply create a trust. Now, let's talk a little bit about the structure of the trust, Clearbud. The structure of the trust. I did speak about some of that last week. Could you tell our audience a little bit about different types of structure that they can choose? We don't have to go through all, because as you know, there's a whole lot of different types of trust, but most of them are not going to be applicable to most of the audience here, because some of those trusts, they're like for if you have billions of dollars and you could do offshore trust, you can do a trust to protect you from tax consequences. There's all different types of trust, but the ones that we think are limited and applicable to our audience, could you tell them a little bit about the structure of those trusts?
Well, I think the main decision that they would have to make is between a revocable and an irrevocable trust. And it's just a big word for meaning a trust that you can control in the case of a revocable trust, and in the case of an irrevocable trust, a trust that you give up control. And now you got to understand that a trust is a person, for all as far as the law is concerned. It's an individual. It's a new person you've created. This is the magic of law, right? We create people. And an irrevocable trust has its own ID, its own social security number, right? And you can open an account in the name of the trust. You can open an account in both, uh, whether it's revocable or irrevocable. But an irrevocable trust is a totally new identity. The revocable trust, you can use the social security of the person who is creating the trust, the grantor, who's the person who's making the trust, right? And then once so in making that decision, you have to think about what your assets are, what is it that you want to do. Uh, and a revocable, of course, you'll have some control. You're probably dealing in this case with children who are the beneficiaries who are minors, and so they can't make the kinds of decisions that an adult can make. So you might want to consider a revocable trust, as opposed to an irrevocable trust, one that you have no real control over. Now, and in the revocable, you can remain yourself. The grantor can be a trustee as well and make decisions, decide who's going to get what, change their mind if you wish, add new assets to the trust. You buy something new and you want to give it away, you can add that, amend the trust. The grantor can do all of that in an irrevocable trust. In an irrevocable trust, it's a little different. That you can make changes, but oftentimes you have to seek court recommendations to do that. Then there's the issue of care in the event that you get sick or you need to go to a nursing home. A lot of us don't like to think about these things, but they happen. The nursing homes are filled. So certainly people are getting sick and too ill to be cared for at home, and they end up in nursing home. You want to protect your assets from that. from the nursing home seeking compensation for whatever payments they need. And it's not the nursing home really that looks after it as a legal matter. It's Medicaid who's coming after you 9 out of 10 times. Um, so in order to protect yourself, it's a state by state, and some states will protect you under irrevocable trust, and other states may not. So you have to look at the state that you're living in, and some states will only protect the assets that are in an irrevocable trust that you don't have any control of. So again, you have to go deal with the state that you're in, and others, of course, they may come after either, but and then there's a 5-year look back, they call it, depending on when you made the trust. So you probably need to do it now. You can't wait, because you never know. We have no control of when we're going to get sick, when we're going to need a nursing home or medical care, or God forbid, when we're going to die. So
I mean, exactly. And that's one of the things that it makes a distinction with the will also, Claremont, is the fact that if you have a will, the property still remain in your hands. So the Medicaid could still put a lien on that property. That asset is exposed. But when it's sitting in a trust, the asset is protected. Medicaid cannot put the lien. And then, like you rightfully said, the look back period, because they look back to a certain amount of years to determine when did you divest yourself of that property. And if it's under a trust, the trustee is the one who holds that property under the trust or as trustee for you. Or in some cases, if the trust is created with its own independent identity and you want the trust to hold the property, that's a different situation there. And that's a different discussion. But it protects your asset in so many ways that if you go settle for the will, you're exposed. And at any point with a will, if you get sick and you ended up and you need to use Medicaid to pay your nursing home bill or assist for your health care, then that's a problem. That's a big, big issue. And children, both parents and children watching this program, more so for the children, they're the ones coming behind the parent. They need to ensure that the parent make the right decision to protect the property, protect the asset, so that when it comes to time for them to inherit it themselves, they don't have to worry that, oh no, there's a $140,000 lien sitting on the property that they would have to pay on the debt of their parent. And then there's the other way. I think what also protects the property is the life estate, because they look back about 7 or 8 years is the look back period if you do a life estate, because the life estate basically divests the testator of the property, and it is really in the hands of their child or whoever they give the remainder estate to. So the life estate would run for the period of their life, and then whenever they're gone, but they don't own the legal title. Because once you do a life estate, you cannot take that deed back without the consent of the remainder life estate tenant. All right, so that's just one of the other way, apart from the trust, that people can use to protect real property only, because that's only limited in the discussion where we're speaking about real property. It doesn't apply to other types of assets like an investment account, a 401k, money in your account, like you would say heirlooms, jewelry, and those other types of assets are protected otherwise. But as it relates to the people were listening earlier, and I know you heard, well, I'm Guyanese, so I say the Guyanese way. I say revocable or irrevocable, but Claremont says his pronunciation is more like the American pronunciation. So for those of you listening, revocable means you could terminate it. You could say, well, I'm going to revoke this. I'm terminating it. I don't want to move forward with this trust anymore. The irrevocable one means it cannot ever be messed with. You can't terminate it. You can't tamper with it. It has to remain put for the rest of your life. Or like Clement was saying earlier, you probably have to get the intervention of the court to do something if you wanted to change your mind on the trust. Right? Now, Clement, could you tell the audience, is there any other method that you would recommend other than the will and the trust we spoke about to protect their assets or to pass it on with minimal, and I stress this part, minimal expenses to their surviving beneficiaries?
Well, the only other way I can think of is and sometimes I do advise, depending on the value of the property and what the mortgages on it and so on, to transfer to that the beneficiaries while they're alive. Just do a deed, quit claim, saying, I'm giving you everything that I own, and you register that with the county as you would any other deed. It's relatively cheap. It's going to give you a little peace of mind, but you still have to look at the tax consequences for the grantee, the person who's receiving the property, and I think that will be determined by what you paid for it, what the mortgage is on it, and so what value you're transferring. Because if the property is valued at 300,000, for example, and it's a $250,000 mortgage on it, then that value that you're really getting is not, you're getting the person who's granting may have to pay tax on the, because they're getting rid of a mortgage. Generally, when you transfer your property, you're getting rid of the mortgage, so you're gifting it, and so you get the benefit. You may have to, the grantor, sorry, may have to pay tax on that mortgage, while the grantee, your child, um, is only going to pay tax on the difference between the mortgage and the value, which is the $50,000. So I don't, I would, I keep all those options in play when I talk to clients about, giving the children their property while they're alive. The problem with that is that you can't control the minds of children. You can't.
Yes, there must be a caveat, a
Yeah,
caveat on that one.
you can't buy love, and you can't buy the love of a child. Sometimes they decide, what, nursing home is, where you're going to go, even though you specifically they said, I'm giving this to you because I don't want to go in, nursing home. I want you to take it, but you're not in control anymore of the house once you give it. So unless you know your child and have a real confidence in them, you need to think
And
carefully.
even so, Claire, but I would put like I said, a big caveat on that one, because I've had instances where I've literally seen this, because I've had to defend litigants in a situation where the parent did transfer over the property to the child, and then the child wanted to sell the property and dispossess the parent of the property. So like that's a big caveat. That's why for me I would say do a life estate if you really want to benefit your child. Just do a life estate if you want to choose that method.
Now,
And
let
like
me
Femi
ask
said,
you a
the tax
question.
consequences.
Let me ask you a question, Sean. If you're doing the life estate, would you do two deeds, one transferring to the child and one to yourself, or is one deed where you put the life estate in that deed?
No, it's one deed for the life estate, and the deed clearly states life estate reserve for. So anybody who's trying to buy the property, they will look at the deed and be like, oh, wait a minute, you have a life estate, so let me see the debt certificate. And if you can't produce a debt certificate, that means the property cannot be transferred. So I think rather than giving it, full out to the child, reserve your life estate. It's just an estate. That's all it is. It doesn't give you a legal right to the property. Neither does it give the child an immediate legal right. The child is taking the property on condition. So it's a condition there. So when you die, then that child could take that property and sell it, or do whatever it is that they would like to do, or if they want to evict you or whatever. But once you remain there, that child could never evict you, never tell you, I'm going to throw you into a nursing home. They cannot. You have to stay there, remain there for the rest of your life. And that child will just have to wait to receive what is called the remainder estate from that. So I think that's one of the other easiest way around this, the trust. But like we said, the trust is always your best, your safest mode, your safest bet. Go with the trust. If you have to choose between a trust and a will or a life estate, go with the trust. And then your second best option should always be a life estate over a direct transfer over to your child, to protect you. The life estate will protect you from any type of lien being placed on that property. They do an 8 years look back for the life estate. So as long as you do it in adequate time, that child's interest will be safe, and there's no need to concern yourself about a lien if you have to use Medicaid. Okay, so these are all the ways that we've given you today. We're not gonna, like I said, we're not gonna give too many different types. There's different variations of trust that we would not be getting into this afternoon, because if we did, it probably will not be applicable, because some of these trusts are only applicable where the grantor of the trust has like millions of dollars and they're trying to protect that, and then they need a perpetual trust like the Hershey's trust, clear, but the Hershey's trust it continues in perpetuity, and that is a never-ending, never-dying trust that will continue from generation to generation, and it benefits complete strangers who are not even related to the grantor of that trust. Mm-hmm. So those are other different types which we don't need to concern ourselves with this afternoon. Now, one other thing I want to discuss as it relates to parents trying to benefit their surviving children or grandchildren. Would you suggest leaving a grandparent, leaving assets to the grandchildren, either by trust or in a will, if they would like to benefit? Let's say they have grandchildren, the children are fine. They say, okay, I don't want to benefit my children because they already have, but I would like to leave this asset to grandchildren. And what if some of those grandchildren are not even born yet? How do you suggest getting around that?
Well, you may have, for the ones that are born and whom that person the grantor may know, they make an assessment of that person, and they feel that that person is worthy. There's nothing wrong with making a grant to them within a trust. Part of this discussion, you can't exclude. You did mention other accounts and so on that you may name a beneficiary, so you have to bear that in mind. Like a 401k, if you're married, it will go to the spouse, or you can agree with the spouse to transfer that beneficiary's status to someone else. Insurance, of course, can go directly to the named beneficiary. And you can also list the trust as a beneficiary to insurance, so that if something happens to you or someone else, the payment. This is really how they perpetuate the income, because on one level, buying a house is what it is, right? You buy and then you build up equity and so on. But sometimes the cheaper way might be to just get insurance and make the trust the beneficiary, and so you keep insuring everybody in the line that comes, including the ones that are not born yet. They're insured even before they're born, and so that money keeps going and rolling and rolling and rolling. We probably need to do another show on insurance and how that has played, or how that could play a role in financial sufficiencies, sustainability, and also historically, because we are, as people of African descent, we were ourselves insured as when we were working for free. And so that system is part of the system that has built up the economic system that we now find ourselves a part of. We probably need to do a show on insurance alone and how to handle that. Maybe we bring an agent who is familiar with that history that could really explain it. But I think I might have forgotten the question. But if you're giving to grandchildren, there should be no bar to if you give to a child who is still of childbearing age and doesn't yet have a child, then in a way you're giving to that child who's not born. And if the grandchild is alive and born, then you can give directly. You don't have to go through the parent. Nobody has a right to your estate except a spouse. Fortunately or unfortunately, you cannot disinherit a spouse, but children have no right, so you can give as you wish.
I'm glad you mentioned the spouse, because some people might have been wondering if their spouse give the estate to the trust prior to death. what happens to them. That's where if all your estate is passed in a trust, then once you die and you have no will, your spouse would have to go file what is called letters of administration, and then they'll make an election. They'll file for their elective share of whatever your estate was. Even because you are a beneficiary under that trust consists of what you would have been entitled to while you were alive. And that's what the beneficiary, that's what your spouse may be be entitled to, because I have to use a caveat there, because if it was pre-acquired property, then there's nothing there for you to receive. Anyway, guys, it's now 4:30. Our time is up, and I see some of you asking for my information. I will put that up in a few minutes, but I just want to say thank you so much, all of you, for joining us. I see somebody's asking, the morning is asking, where is Mr. Chung office located? If you want to get in touch with Clearman Chung, he's associated with Washington Law Firm, and I will put that information up here for you in a few minutes. So if you're trying to get in contact with him or any of the attorneys you see come on this show from time to time with me, you can just literally call the Washington Law Firm at any time and ask if we could, Mr. Chung, and we will put him or schedule an appointment for you to speak with him. All right. Thank you guys so much. It has been our pleasure. And I will have Clement give you his closing remarks before we leave.
Manage your money, get advice, get a tax attorney, get an attorney, and you should be good to go.
Thank you so much, Clement, for joining me this afternoon. And thank you guys so much for being such good listeners and rallying with us to share the link. We are so thankful. Stay with me, hang there for a few minutes. I will put the commercial up so you will get the phone number. I encourage you, if you need information, legal advice, give us a call the number, and we'll be able to give you some advice based on your individual situation. Remember, the show is only for educational purposes, and it's not intended to give you individual legal advice. If you need that, again, guys, give us a call the number, and we'll be able to provide that. Thank you so much, guys. Enjoy the rest of your weekend. I believe coming up at 5 p.m. is Over to You with Wayne Caesar. Thank you so much, guys. Have a good rest of your weekend. So this is attorney Shellon Washington, owner and founder of the Washington Law Firm, located at 455 Utica Avenue in Brooklyn, New York. We're specialized in medical malpractice, personal injuries, matrimonial law, and landlord and tenant. If you're in need of legal representation, please give us a call today. The number to call is 718-877-3100. Consultation is free at no cost to you. So call us today to see if we can be of any assistance to your legal needs. Again, the phone number to call us is 718-877-3100.